Good afternoon, everybody. Thank you so much for joining us today on this webinar, the Cross-Examination Workshop with BPP. My name is Nahal and I'm part of the events team here at Target Jobs. We're thrilled to be joined by the BPP team, both Nigel Jamieson and Millie O'Connell, who'll be sharing more about who they are and about BPP as an organisation in this exciting cross-examination workshop for barristers. Just a couple of housekeeping rules for you all before we begin. If you've got any questions throughout the webinar, please pop them in the Q&A tab, and one of the team will go through and answer your questions. And also make sure to show your appreciation throughout the webinar in the chat tab at the bottom right as well. For now, I'll pass over to Nigel to kick things off. Thank you, Nigel.
Thanks, Nahal, and thanks everybody for joining. It's good to see so many people in the room. So yeah, just a little bit about myself, just so you know where I'm coming from, and my colleague who's joining me today, Millie O'Connell. So I'm a barrister. I'm head of law at our Leeds BPP centre. At BPP, we've got centres that have law schools in the north, in Leeds and Manchester, further south, Birmingham, London, Bristol and Cambridge. And I was in practice as a solicitor initially since 1995, and I transferred to the bar later. So I worked as a solicitor and a barrister, doing mostly or almost completely criminal litigation, mostly defence work, a little bit of prosecuting as well in that time. I came to BPP 6 years ago now to teach advocacy primarily on the barrister training course, as it's now called. And that's what I still do, in addition to overseeing the other programmes as head of law there. So that's me, a little bit about my background, and I'm joined by Millie. Do you want to just introduce yourself briefly, Millie?
Yeah, hi everyone. So I'm currently a student on the BTC with BPP at their Leeds campus, and as of September I'm starting my pupillage with Park Square Barristers, also in Leeds.
Thanks, Millie. So yeah, I've been, amongst others, teaching you some of the submission advocacy and the other oral skills that we're going to look at briefly today. And you've got assessments coming up, haven't you? Don't want to remind you unnecessarily about that, but you're at the end of your teaching, aren't you? And just going into your final assessments. So thank you for taking the time out to help us today. This is, as it says there, an introduction to cross-examination. Actually, I should, just before I move on, just flag up the fact that I've put my email address on that slide, nigeljamieson@bpp.com. Happy for you to reach out after the workshop if you'd like to, if you've got any particular questions or anything that's confused, that isn't clear as a result of what we've said. Feel free to put comments or questions in the chat as we're going through. We'll try and deal with those as we get as we're going through. It's sometimes not possible to deal with them all, so feel free to contact me afterwards if you'd like to, or if there's any questions about the course generally that we teach on at BPP. Law Outreach is the other email address there, lawoutreach@bpp.com. People there will be happy to help you as well. And my LinkedIn is Nigel Jamieson. Often it's useful to connect with me on LinkedIn just to keep up to date with some of the things that are going on. Happy for you to do that. So, introduction to cross-examination. It is very much an introduction to one of the skills that are taught on the barrister training course. It can be looked at in much more depth, of course, but I'm hoping just to give you a bit of insight into what's happening with a cross-examination, and hopefully it will encourage you to look into it more. I don't know just where everybody is, what position you're at in your studies or your practice. For those in the room today, maybe that many of you are undergrads who are thinking of going forwards to the barrister training course. Some of you may already be at that stage. You might be thinking about, in your second year undergrad. Thanks. So it may be that many of you are thinking about mock trial competitions and that sort of thing going forward. Hopefully this will give you a little bit of insight into cross-examination, which will be helpful for that. And if you are looking forwards to the barrister training course, it should hopefully give you, again, some insight into one of those skills that we'll be teaching you or that you'll be taught on that course. As far as advocacy generally is concerned, you can think of it as 4 separate modules, because they are 4 separate modules, each of which is assessed separately on the barrister training course. And they're all quite separate skills, but they arise out of advocacy generally in the courtroom. Just so you know, you have submission advocacy, which is a different skill. That's where it's you making an application to a judge it's just you and the judge, so it's presenting your arguments in support of an application in a particular way. There's conferencing skills, which is something else again. That's where you're sitting down with your client, taking instructions and advising them as to what might happen in the case, what their options are, the strength of the case, that sort of thing. And then you've got two things which we refer to as witness handling. Examination in chief is one, and cross-examination is another. Quite separate skills, although of course there are some overlap in those. And I'll just make sure you understand just what cross-examination is, as opposed to examination in chief in a moment. So what we're going to do is just focus primarily on cross-examination, of course, here. As I say, give you a bit of insight. I'm going to start just by covering briefly just what it is and what you're trying to achieve in a cross-examination. We'll talk a little bit about the types of questioning techniques that you need to be aware of when carrying out a cross-examination, and then a couple of broader techniques, hopefully, which will give you some insight into what you're trying to achieve during a cross-examination and just how to do that to best effect. And what I hope is that when you watch or listen to a cross-examination, and I do urge you to go to court whenever you get the opportunity to do so and watch trials, hopefully you'll think to yourself, oh yes, I can see just what's going on there now, and it will hopefully make a bit more sense. What I find with cross-examination in particular, students often think that it's going to be the most tricky of those skills, but in fact, when you take away the mystery of it and you realise just what's going on, and you know how to prepare it, then it can be relatively straightforward to deliver, in fact. Let's just have a look at what it is when it happens and what's the point of it. As I'm talking through this, feel free to put in the chat, if you like, just, I suppose, the answer to that third question. What is the point of it? What are you trying to achieve in a cross-examination? What are your objectives? Feel free to put your thoughts about that in just as I work through the slide. So what is it, though? In simple terms, straightforward terms, the cross-examination, as distinct from examination in chief, is questioning of the other side's witness. Important to remember that. Examination in chief, a very different thing. Examination in chief is when you're asking questions of a witness that you have called. What's the difference? Well, the witness that you have called and who you might be examining in chief is presumably a witness that is supporting your case. The cross-examination arises when you are dealing with the other side's witness, who presumably is not necessarily going to be very helpful to your case, although an effective cross-examination can bring out things which do support your case, and that's really one of the objectives of it. It's important just to think about where it arises in a trial. So when does it happen? I've put on the slide there, because it's just useful to be clear about the context in which an examination in chief arises. Again, put simply, a criminal trial will usually start with the prosecution making a brief opening speech to the jury. They will just tell the jury what the case is about in broad terms. They won't go into any detail about the evidence they're going to hear, but they will just give the jury a bit of context about what's coming and what the issues in the case are likely to be. But not much happens there. What really happens, and the only things that they hear that they can actually use to help them make their decision, is what comes from the witnesses, because what the advocates actually say is not evidence. So what happens first after that opening speech will be the calling, usually of a live witness who will give evidence in chief. So the party, the prosecution, in the normal course of events, will call the witness, will examine their witness in chief. So ask the witness questions, get them to tell the court just what they know about the relevant points. When that witness has finished giving evidence in chief, so when they've given their account, given their story, that's the point at which cross-examination arises. And that's the point at which, if I'm defending in a case, I would stand and I would cross-examine that witness. So you need to remember that that witness has already given their account in examination in chief, said everything that they want to say about the case, and that's the point at which the cross-examination starts. So what is the point of it? I was looking in the chat there. Asking closed questions compared to asking open questions. I know what you're getting at there, Speranza. I'm going to come to that in just a few moments. I think you're thinking about leading and non-leading as well, aren't you, as well as closed and open. Andreas, to test the credibility of witness and support your argument. Yeah, and Louis, discrediting a witness or the defendant's evidence. Yeah, so I would say that if you're looking generally at I'm just jumping ahead to a slide ahead there. Yeah, what is the point of it? I'll stick with that point at the moment. What I would say the point of the cross-examination is, and this links with some of the comments we're getting there, you're trying to undermine the witness, certainly. And when I say that, you're trying to demonstrate that they are either generally unreliable and therefore the jury should not attach too much weight to what they tell the court, or demonstrate that what they are saying on a particular point in this case is unreliable. So you might want to demonstrate that they are unreliable generally, or that they are unreliable in relation to a particular point. A little bit more than that, though, and this really feeds into what I'm going to go on to talk about. It's worth thinking about your cross-examination as an opportunity to demonstrate what your case is, demonstrate, if we're looking at it this way around, what the defence is, and more particularly, demonstrate points that assist your case. I stress the word demonstrate for reasons that I hope will become clearer, because it really is worth thinking about your cross-examination as a platform, really, for you to demonstrate to the court points that assist your defence case and drive it forward. And that's a useful way of thinking about it. And I hope that will make more sense when I come to give some examples. But just leaving that there for the moment, let's look at the type of questions. I've got the question and the answer to that particular question there. What type of questions should be asked? Leading questions. I think if most people were asked, can you ask leading questions in cross-examination, they will say yes. However, it's important just to be clear about what a leading question is. And that's worth just inviting you to think about in the chat as well. Does anybody, or can anybody explain as clearly as possible just what the difference is between a leading and a non-leading question? Let's give you a moment to think about that. And just whilst you are, I would say that as far as examination in chief is concerned, which is not the focus of today's workshop, this is a particularly important concept. As far as cross-examination is concerned, you're not necessarily breaking any rules if you get leading and non-leading mixed up, but it is much more effective if you do ask leading questions, which is why it's important to be clear just what the difference is. So non-leading has, just looking at the chat's just moving up as I'm looking at it, more to do with the direct facts of the situation or any question, Monish, you've put which suggests an answer or presupposes a fact. Speranza, a leading question allows the witness to tell their story, where a non-leading question is more likely to be answered with yes or no. Yeah, I think you're drawing together different sort of ways of thinking about it. Monish, and Andra, I think, I was looking at a leading question is one which suggests the answer to the witness rather than actually letting the witness explain the answer themselves. Yeah, a combination really of what Monish and Andra are saying there. I would say that a leading question is one which suggests the answer to the witness. That's probably the easiest way to think about it. And if I just jump to the next slide, let's look at this definition. A leading question, one that suggests the correct answer, or one that presupposes a fact. Leave the second definition for the moment, but focus on the first, one that suggests the correct answer. If the witness is able to simply agree with the question, then it is very likely to be a leading one. I think that's probably the best way to think about it. So one that suggests the correct answer, if it's easy if the witness could simply agree with me when I put the question, then it's likely to be leading, because really I'm feeding the answer, I'm leading the answer into the question, rather than requiring the witness to engage their own memory, their own thought process, and actually tell the court without being prompted what the actual answer is. And that makes sense, doesn't it? If in certain circumstances, if I was examining in chief in particular, it wouldn't be fair, would it, if I'd simply fed the evidence to the witness and they said, yes, that's right, yes, that's right, yes, that's right, because that would be me giving evidence and the witness just confirming it. That doesn't enable the court to really weigh up whether what the witness is saying is correct or not. Now, I've added to that one that suggests the correct answer. I've deliberately put the word correct in there because, well, let's look at this example. Which of the following is a leading question? What colour was the car? Is that a leading question? I won't leave you just to throw out answers to this in the chat just for a moment, but you can. There's one or two coming through. What colour was the car is an example of a question that is not leading, is it? Because the witness can't simply agree with that question. The witness has to engage their own recollection, their own thoughts, and tell me that the car was blue, if that's the answer. So that's not leading. The second question, was the car blue? Is that leading? Some people are saying the third option is leading, and some people are saying not the first one. Well, you're right, the first one is not leading. But I would say the second and third are both leading, because I am feeding the answer to the witness there, aren't I? If I say, was the car blue? The witness could simply say yes. And if I say the car was blue, wasn't it? Again, the witness can simply say yes. The reason I've put two variations of the blue question, second and third answers there, second and third questions there, is because they're slightly different versions of a leading question. The first one is certainly leading because the witness could say yes. The third one is also leading, but it's leading in a more assertive and positive way. And I've put that example in because that's the kind of leading question which I want you to focus on. So the reason I said a moment ago, I added the word correct into that definition of a leading question. I won't dwell on it too much, but one that suggests the correct answer. If I know that the car is blue and that's what I want the witness to tell me, in fact, it would be all right for me to say, was the car red? Because the witness can't just agree with me and get the correct answer out. I just flag that up because sometimes if you are struggling to get a witness to know what general fact you're getting at, sometimes suggesting the wrong version of that can be useful, and it's not leading because the witness has to actually correct you and say, well, actually, no, it wasn't. This was the case. So that, I just flag that up. I don't want to get too tied up with that at the moment. But if I wanted the witness to tell me it was raining, it would in fact be all right for me to say, was it sunny on the day you're talking about? And they would say, no, in fact, it was raining. So I flag those up at the moment just to get clear the concept of what's leading and non-leading. Not because for cross-examination, it's as important as examination in chief, where you can't lead, but because I really need advocates or students who are considering cross-examination to really know what's leading and what isn't, because you should in fact be leading when you are cross-examining. You don't have to, but you can. And I would say not only can you, but you should. Why? Because when you're cross-examining, you really should be controlling the flow of information. And it really leads me into the, I suppose, the next slide, really. Again, I don't want to spend too long on questioning technique, but when you are using leading questions, which you should be doing in cross-examination, the reason for that is because of these things on this slide. You want, first of all, and this sounds a little bit counterintuitive, doesn't it? Because if you're asking questions, surely you want the witness to give answers. Not necessarily. And I think this is a way of approaching cross-examination that's useful. You know, I said earlier on, think of your cross-examination as an opportunity to demonstrate points that assist your case. You're more able to do that if you can, in fact, control the flow of information so the witness is saying as little as possible. Sounds odd, but bear with me, and it will make more sense. You don't really want the witness to have a platform to repeat their evidence in chief, because don't forget, this is not your witness, this is the other side's witness. The reason they are in the witness box is usually because they are harmful to your case. They are there to support the other side. So I've seen lots of cross-examinations over the years when I thought the advocate is giving the witness a platform just to repeat evidence against your own client. And that is not just a waste of time, it's actually harmful to your case. So you want to control that. You don't simply want to give the witness the opportunity to go over their evidence in chief again. And you can do that by asking very leading questions and putting facts in a way that helps you demonstrate your case. And we'll look at an example in a moment. Just dealing with these basic concepts, though, and they're worth making a note of. Don't try to learn anything new in cross-examination. Again, for the same reason, if you ask a question which is fairly open and you're inviting the witness to simply tell you something you don't know the answer to yet, again, remember where this witness is coming from. They are probably not going to say anything helpful because that's not necessarily what they're there to do. And perhaps more importantly, it's just risky. You don't know what they're going to say. And you shouldn't really be going into a cross-examination hoping that you are going to learn something which assists your case. It's a risk. It might be a calculated risk you take sometimes, but that's not really the way you should be focusing your preparation for it. So use facts to demonstrate points which help you rather than trying to learn something new in a cross-examination. As I say, we'll come to an example. Just as we build towards that, look at these last couple of points as well, because they underpin everything we're talking about. Don't try to persuade the witness. I've seen lots of cross-examinations again in the courtroom in real life and in the mock courtroom in student exercises, where the advocate has really thought that the aim of the cross-examination or a successful cross-examination is one where they have persuaded the witness to agree with them. I would say you might get lucky. I either never or very rarely did in 20 odd years in the courtroom. It's not generally what happens. It happens on the television. It happens on in books, perhaps, you know, where cross-examinations taking place and the witness says eventually, oh, you've got me. You're right. Everything I've said before is wrong. You've caught me out. It doesn't tend to happen in real life. And it doesn't matter whether you persuade the witness, of course, does it? Remember this, the witness is not the one who is delivering the verdict in the case. The jury is, or the magistrates are, or a district judge perhaps, but not the witness. So your aim is not to persuade the witness or change their mind. Your aim is to persuade the audience, let's call them that. And so it doesn't matter too much what the witness says in response. What matters is whether in your questioning you're demonstrating facts which are persuasive. Don't argue for the same reason, really. You should, if you end up in an argument, it's probably because you're not controlling the flow of information and you're not using that cross-examination to demonstrate points. If you end up in an argument, it will probably be confusing, ineffective, and it's just not what you should be looking for. So with that in mind and those basic ideas in the background, let's just move on a little bit and hopefully some of these things will be drawn together. Bearing in mind the need to use leading questions, bearing in mind the need to use your cross-examination as a platform to demonstrate points that assist your case rather than getting into an argument, bearing in mind you don't need to persuade the witness of anything, but you do need to persuade the audience, i.e. the jury, for example. Let's think about this technique, which is one way that you would do that. And what we teach on the barrister training course at BPP is this technique in particular. In some cross-examinations, you can do a lot of this, and you will see this technique being used if you go to the courtroom to watch. What am I talking about there? I'm talking about the general idea of finding facts, and by facts I mean facts that are not really in dispute, things that the witness is likely to agree with. Finding those facts, usually from their own evidence or just from common sense, general knowledge, and using those facts to build to a conclusion that helps your case. Ideally, the witness will agree with the facts that you're putting, although they may not agree with the conclusion when you get to it. But that doesn't matter, does it? Because hopefully the jury listening to it will be listening to the facts you're putting, and they will agree with the conclusion if it makes sense. So the important thing here, and the technique here, is to do it the right way around. There is an effective way and a less effective way of doing this. Let's look at this example. Let's assume we're dealing with this case. D, that's the defendant who you're representing, is charged with an offence of burglary, which happened at 7 p.m. on the 10th of January. Now, part of the prosecution case against the defendant, your client, is that he was seen, they would say, running away from the scene of the crime at the relevant time. The evidence for that comes from a witness who knows the defendant, and that witness was looking out of a kitchen window at home. And the following, which I'll just come to, is an extract of what she has told the court in her evidence in chief. So remember, each witness will have given their account to start with in evidence in chief, and then you're cross-examining. So that's the background, that's the case. And what the witness has told the court already in examination in chief is this. She says, 7 p.m, I was in my kitchen at the sink. It's in front of the window and overlooks the street. And that's when I noticed a person on the opposite side of the street. Attention drawn to that person because he was running. That's what caught her attention. He also looked suspicious to me, she says, partly because he was wearing a hoodie with that hood up. And I immediately recognised that person as Alan Cousin. That's your client, the defendant, by the way. I went to school with Alan and he lives about half a mile from me. I see him about twice a week and I'm sure it was him. So that's what the witness has said so far. And on the face of it, sounds quite compelling, doesn't it? At first listen, she's saying, I'm sure it was him. She's not in any doubt about this. She sees him twice a week. She went to school with him, lives about half a mile from me. Immediately recognised that person as the defendant, and her attention was drawn to him for those reasons. Are there any facts there, though? Any facts within that scenario that you could use which might help you to demonstrate to the court that she could be wrong? I should clarify, your client is saying she's mistaken. It wasn't me. And you want to demonstrate, don't you, to the court that she either is wrong or could be wrong about this. We're not necessarily saying she's lying. That might be a different sort of case, really. But I do want to demonstrate that she could be mistaken about this. So, yeah, throwing in a few things there. Natanya, you're saying the hood is pulled up. Yeah, so there was a hood, wasn't there? And as soon as you see that, you think, okay, that could cause some problems. Never mentioned seeing his face or any identifying features. Yeah, so she's not got much detail there, although she thinks it was definitely him. Dark at 7 p.m. Yeah, so look at the circumstances. Not just 7 p.m, but on the previous slide, we know it was 7 p.m. on the 10th of January. So as of today, with the clocks changing, 7 p.m. might be light, but not necessarily on the 10th of January. Hoodie up whilst he was running as well, yeah. And Clara, thank you, and Lydia saying 7 p.m. dark outside. You said half a mile is long distance. He lives about half a mile. Oh, yeah, you're talking about living half a mile away. There's a few things there, aren't they? The hood being up, He was running, has been noticed, and opposite side of the street as well. Don't know just how far away that is, but probably through a window as well. And it was 7 p.m. It was dark. So a few facts there which I can use to argue or to demonstrate that she might be mistaken. Now, what I said a moment ago is that there's an effective way and a less effective way of doing this, and the order in which you do it is important. I mentioned earlier that this technique is called building through facts to a conclusion, and it's important to remember that. I want to build through the facts and then show the conclusion, because if I do it the wrong way around, it's going to be less effective. Let's look at an example of this. Now, Millie's going to help me here. She's going to play the part of the witness. And I'm going to run through just two versions briefly of this line of cross-examination. And I want you to think and maybe just put some comments in as I'm going along about which is more effective and why. In one version, am I doing it in a less effective way? What am I doing that I could be doing better? So let's look at this first example. In fact, I don't mind saying, to put into context, the first example here is the less effective version. But would you just perhaps put comments in the chat as to why? What am I doing wrong? What could I do better? So, are you ready, Millie?
Yep.
So you are the witness. So I'll begin my questioning like this. I might say, you're wrong, aren't you, when you say it was the defendant running away?
No, it was definitely him.
Well, let's look at that. You could have made a mistake, couldn't you? Because you didn't get a clear view of his face, did you?
No, I did. I got a really clear view of his face. It was definitely him.
Are you sure about that?
100% sure. It was definitely him. I'd bet my life on it.
Well, how can you be so sure?
I got a really clear look at him and clearly saw his face. It was definitely him.
Well, how far away were you?
I was quite close.
Well, you say quite close, but how close is that?
Close enough to get a good look at his face.
But you must agree, surely, that watching from your kitchen window when the person was on the other side of the street means that you couldn't have got a clear view of that person, could you?
I did. I was watching from the kitchen window, but the window's only 2 meters from the street, and the street is narrow with no parked cars or any obstruction, so I saw him clearly as he went past.
Well, wasn't it dark? How dark was it?
Not very. I could still see quite clearly.
Well, how could you see clearly?
There were street lights.
Well, surely you couldn't see his face clearly, though, because he had his hood up, didn't he?
I mean, he did have his hood up, but it didn't come all the way around the front of his face, so I could still clearly see his face.
Well, I'm going to put it to you that you've only got a fleeting glimpse of that person because he was running away at the time, wasn't he? It happened really fast, didn't it? It was too fast for you to be sure.
No, not at all. He was running, but only jogging slowly, and he kept looking around, so I got a really clear view of his face.
But all in all, you can't be sure it was him, can you?
Yes, I can, 100% sure, because as I've described, I got a really clear view of his face.
Mm-hmm. No further questions. Okay, so you'll be able to compare that with what we'll do in a moment. But I noticed one or two comments as we're going through. Accusatory tone, yeah, let's not worry too much about the tone for this purpose because we haven't got time really to deal with the delivery and the subtleties of that. But you are right that, Melissa, that you do need to think about the tone as much as other things. Somebody said, I think the chat sort of develops and said, somebody said that I'm allowing the witness to add more detail in, and fundamentally that is a problem there, isn't it? Have I clearly demonstrated to the audience that she could be wrong, or have I just got into a bit of an argument with the witness and allowed her to justify her own position? I think the latter, really. Janenia, yeah, I think you're saying, yeah, no, really. I think that you mean I haven't really demonstrated very clearly, have I? And Natalie, yeah, the latter. And that's the problem with that. I have tried to effectively argue it out with the witness, and I've given the witness the opportunity to really entrench her position and argue their point, and argue that they are sure, despite those facts, rather than allowing me to demonstrate that she could be wrong. Become clearer, I think, in the second example, and see just if this works more effectively. You saw the person in question from your kitchen window, didn't you?
Yes.
And that person was on the other side of the street, wasn't he?
Yes.
About 10 to 15 metres away, presumably?
Yeah, about that.
Now, this incident happened on the 10th of January, didn't it?
Yes.
At about 7 p.m.
Yes.
So it would be dark by then, wouldn't it?
Dark-ish, I suppose.
And you described that person as wearing a hooded top, in fact.
Yes, that's right.
And you remembered that because the hood was up.
Yeah, he was definitely wearing a hoodie and his hood was up.
And you've told the court that your attention was drawn to him because he was running.
Yeah, he looked dodgy, like he was running away.
So you were 10 to 15 metres away. It was dark. He had his hood up and he was running away from you. That's right, isn't it?
Yeah, that's right.
And so the reality is you didn't get a clear look at his face, did you?
Yeah, I did.
You could be mistaken about who it was.
Absolutely not. I swear it was him. You're talking rubbish. It was 100% him.
I have no further questions. So what's happened there? I think, comments there. These are closed-ended questions, not allowing her to give too much information. That's one thing that's happening there. I'm not just leading, I am putting facts one at a time, and I'm limiting the witness to yes or no answers. More importantly, I'm putting facts which I'm sure that the witness is going to agree with. And that is ideally what you're looking for. So when I say this technique is building through facts to a conclusion, I really do mean flat facts. And if I can get those facts from the witness's own evidence, then I almost can't lose, really. The witness has to agree with those facts. So when I asked you all a few minutes ago to, what facts are there that are useful? Well, we identified, didn't we, the 7 o'clock in January, dark, the distance involved because it's the other side of the street, looking through a window, hoodie, hood up, the fact that the witness was running, so the person was running. I've just drawn together those facts, put those one at a time, got the witness to confirm those, and having built the foundation with those facts, I've only then put the conclusion which is supported by those facts. And it's so important to do it that way round, because in the first example, I started with the conclusion. That was the big mistake in the first example. I put to the witness that she could be mistaken. She said no. And then I tried to argue it out by putting those facts. Now, what the witness does in those circumstances is resist and push back against each of those facts and minimize them, because the witness wants to support what I've challenged, which is whether she could be mistaken or not. So what happens in that first example is much less effective, because the witness is pushing back all the time and trying to minimize. So when I said it was dark, they said, yeah, but there was lighting, there was street lighting. They'll find a way to lessen the effect of those facts and minimize them. Much more effective simply to put the facts when the witness doesn't really know where you're going with it, and then put the conclusion. Now, what Millie did quite properly at the end of that, at the end of the better version, was still push back against the conclusion. I think your answer was absolutely not. I swear it was him. You're talking rubbish. It was 100% him. Doesn't matter though, does it? Because remember, I'm not trying to persuade the witness. In the build-up to that, I've hopefully persuaded the jury, the audience, if you like, that those facts do justify the conclusion that she could be mistaken. And it's them that hopefully will be persuaded of that It doesn't matter whether the witness is or not. So a fairly straightforward technique, and a lot of advocacy is about almost stripping away the mystery, and just identifying some fairly straightforward techniques which make the process or turn the process from a fairly unfocused back and forth argument into a much more controlled, almost mechanical process where you are presenting and demonstrating points more effectively. And yeah, Janani, you're saying it makes sense now. I hope that does. It's not always as straightforward as that, because of course I might not always have facts like that which really do help me in that way. And it may be that the witness knows exactly what I'm doing and tries to minimize and push back in any event. But the important point is to maximize your chances, be as effective as possible by finding those facts, hopefully fairly non-contentious facts, putting those in a build-up, and then putting the conclusion. Because that really is what cross-examination, or a big part of what cross-examination is about, demonstrating why the witness might be mistaken or demonstrating something which helps you. If you have no facts at all which help you demonstrate certain conclusions, then you've probably not got a very strong case, and you might be struggling. But if you're in a trial and you've got to this stage, then hopefully there will be things that you can use. So if you're ever in a mock trial competition and you have to do a cross-examination, just think about, as part of your preparation, are there facts that I can almost harvest from the witness's own evidence or from general knowledge and common sense which help me demonstrate something that helps my case, and then deal with it in that order. One fact at a time as you're putting them, pick them off, get the witness to agree with them, confirm them one at a time, and then put the conclusion, and then, very importantly, move on. The witness will probably dispute the conclusion. It doesn't matter. You're not going to benefit anybody by dwelling on it and trying to argue it out. You front load it all by putting the facts first. So hopefully that makes sense. That's one important technique, and one which you will see being rolled out in an effective cross-examination if you go to court to watch. And often, if it's a fairly realistic scenario, if you're watching a trial on the television. And a lot of it is just about fairly careful preparation. I mentioned earlier that I don't mind too much what the witness says in response. I'm using it as a platform for me to demonstrate, and bear that in mind. Let's look at one other technique in the few minutes we've got remaining. And as I said at the start, an hour, I don't know how many hours of workshops you'll do through the course of your advocacy and cross-examination, all the other skills, but quite a lot, and quite a lot of preparation and consolidation as well, isn't there, to try and really get comfortable with these and other techniques. This is, as I said at the start, just a brief insight into a couple of aspects of cross-examination, and I can do no more than really just flag them up and give you a flavour of what they are. So that first one was, well, we looked at a little bit about questioning technique. We've looked a little bit at that technique of building through facts to conclusions that help and then moving on. Let's look at one other thing which often arises in real trials, often arises in mock trials. Often these things are deliberately built into advocacy exercises to give you the opportunity to do something with it. We're looking at how you deal with a previous inconsistent statement. Now, this is a different, completely different technique, but it's a different thing really that we're looking at here to the building through facts to a conclusion technique. Before we talk about just how to deal with it, let's just be clear about one or two points here. A witness giving evidence in a criminal trial, this is the general position. A prosecution witness giving evidence in a criminal trial will have given a witness statement to the police before the trial. often months, sometimes years before the trial, usually often very soon after the incident happened, that they can talk about. Now, you as a defence lawyer, as well as the prosecutor, will have been given a copy of that statement. You have to, because you have to know what it is this witness is likely to say when they're in the witness box, what the relevance of this witness is, what they can give evidence about. So if I'm defending in a case and I'm about to cross-examine a prosecution witness, I will know what's in their original witness statement. I'll have a copy of it. However, the jury don't know anything about that statement, and it's important to remember that the only evidence the jury can rely on or get to know about is what the witness says in the witness box. So the prosecutor, as I said earlier, will have called the witness, asked them questions and drawn out from them the account, which is probably broadly similar to what they've said in their original witness statement. But the jury won't know what was in that statement. However, what if I'm defending and I know that what the witness is saying to the court today is different to what they've said in their witness statement? Do I want the jury to know about that? Any thoughts in the comments? Alkin, yes, some short, definite answers there. Yes, absolutely, yes. Depends, or let's stick with Natalie's depends answer. Broadly, yes. Generally speaking, I think I do. Now, that witness statement, as it says on the slide, is not in evidence. They know nothing about it unless I choose in cross-examination to bring that to their attention. So if today's oral evidence is inconsistent with the previous statement, often I will want to reveal that to the jury, but not always. There may be situations where the witness's account today is actually more helpful to my case than their original account. Let's say, for example, my client is charged with assault, and my client says, yeah, you know what, I did assault the complainant. I did punch the complainant. I punched him once, but it was in self-defense. And the court's going to have to decide who started it, what was said, whether this was reasonable or not. Let's take it the other way around, where I do want to deal with it. If the witness in court today says that there were 5 punches, whereas in their original statement they had said there was 1 punch, but the defendant started it. Well, if they said 1 punch in their statement, but now they're exaggerating and they've gone to 5 punches, I need the jury to know, don't I, that in their original statement, they said 1 punch. They're clearly exaggerating now. They're changing their account. What if it was the other way around, though? That's the point I was just wanted to cover briefly. If in their original statement they said there were 5 punches, yet today they're saying 1 punch, and that is broadly consistent with my client's version, then I would leave that well alone, probably, because even though I might want to show that the witness is chopping and changing and not being consistent, I don't want necessarily to tell the jury that their initial account was even worse than today's. So bear that in mind. Not every inconsistency is something you want to expose to the jury, but let's assume we do, because today's account is worse than the original account. There is, as often is the case, an effective and a less effective way of dealing with it. And let's just run through the technique that you will often see being used in court when an advocate is cross-examining a witness and effectively wanting to demonstrate that they've changed their account. Now, we talked earlier about building through facts to a conclusion. It's a similar approach. What I want to do here is demonstrate facts which show that my conclusion, which is that they are exaggerating, my conclusion, which is that their account today can't be correct, because if it was, it would have been in their statement. It's a similar sort of approach. I want to point to those facts, those circumstances which show that today's account can't possibly be correct, because if it was, it would have been in the original statement. Now, of course, I could pile into the cross-examination and in a sort of clumsy way, and the witness will minimize all the points I'm going to make, and at the end of it, I won't be able to demonstrate very clearly that the witness is lying, or I can deal with it in a much more effective way. So let's just working through this slide. What I want to do is get the witness to confirm what they're saying today. I'm not agreeing with it, but I want the witness just to confirm what they are saying. And then, before I challenge that, I just want to confirm the circumstances of their previous statement, the circumstances in which it was made, for reasons that will become clear. Then I want to reveal the inconsistency, and then I want to put my conclusion, which is that this can't be true. Today's account can't be true, because if it was, it would have been in your statement. Let's just go back to the scenario we had here. Let's assume for these purposes that this extract from the witness's evidence is actually an extract from their statement rather than what they've said in court. So what this witness has said in their statement, let's assume, is that they noticed a person on the opposite side of the street who was running, hoodie, hood up, etc. But what if, moving on from that, what they've actually said to the court today is something like, or they've added something in, something like, the person stopped running opposite my house, turned to look directly at me, and I got a clear look at his face. What if that's what they've said to the court today, but what's on that slide there is what I know they've said in their statement? I'll be thinking, absolutely, I need the jury to know about this, don't I? Because this is new evidence. If this was true, this would have been in their witness statement. So I absolutely need to demonstrate that this account today, which sounds very convincing, is a new version of events, which is unlikely to be true. So again, two brief performances. Let's run through them both, one after the other, and perhaps put in the chat why you think why you think one is better than the other. Let's get to the right bit. Okay, so it's not true, is it, that the person stopped and looked at you as you've just told the court?
It definitely is.
Have you told this to anyone before?
Can't really remember, but it definitely happened.
Well, you didn't put it in your statement. Why is that?
I didn't think it was important.
You definitely didn't put it in your statement. Why didn't you think it was important?
Don't know, I just didn't really think it was important to include.
Didn't you realise that the statement could be used in court proceedings and therefore you had to include everything?
Not really, I just thought it was a basic account that they needed.
But surely, if that was true, you would have put it in your statement, wouldn't you?
No, I've had time to think about it since, and my memory's much clearer now. It definitely happened the way that I've described today.
Well, I'm just suggesting that you've just made it up today. That's right, isn't it?
That's not true.
Okay. Think to yourselves, have I demonstrated effectively there that if this is true, it would have been in the statement made at the time? Look at this alternative approach to it. Now, you've told the court today that the man stopped and looked straight at you. Is that what you're telling the court?
Yeah.
Now, you gave a statement to the police about this incident, didn't you?
Yeah.
And that statement was on the 10th of January, wasn't it? Which is the same day as the incident.
Yeah.
So things will be fresh in your mind when you gave that statement.
Yeah.
And that statement was taken by a police officer, wasn't it?
That's right.
And you signed each page to confirm that it was true and accurate.
Yes.
And you signed a declaration, in fact, didn't you, on the statement, which effectively confirms that you believed it to be true, it could be used in court, and that you could be prosecuted if you stated anything false in it.
Yeah.
Can you look at page 2, paragraph 3 of the statement, please?
Yeah.
What it says there is this. It says, I noticed a person on the opposite side of the street. My attention was drawn to that person because he was running, and he looked suspicious to me because he was wearing a hoodie with the hood up. That's what you said, wasn't it?
Yeah.
You made no mention in your statement of the person stopping to look towards you.
Maybe I just didn't think it was important at the time.
The reason it's not in your statement is because it didn't happen, did it?
It did happen.
If it had happened, it would have been in your statement.
It definitely happened.
You're exaggerating today to strengthen the case against the defendant, aren't you?
No way.
Okay, thank you, Millie. So what's happened there? I'm just looking at the comments. First, more like an argument with the witness where, yeah, I'm not really getting anywhere. It's muddled, isn't it? I'm kind of making the point, and the jury will kind of get that this is a change of account. But what I've done in the second version really takes me right back to what I was saying at the beginning of this workshop, which is that you should look at your cross-examination as an opportunity to demonstrate points rather than questioning in an argumentative sense. And when I said earlier, you want to restrict what the witness can say, that's more what I'm doing there. I want the jury to be listening to the points that I am making, the points I'm demonstrating, rather than just an argument, which might or might not be fairly effective. Second time was a barrister at work. Yes, you're right, Adil. That's actually someone, it's doing the job, isn't it, of a barrister, rather than in a fairly forensic, controlled, methodical, trained way, rather than using the technique they're being taught, rather than simply getting into an argument. So what I've done there is demonstrate through facts, which I'm putting, that the new account is unlikely to be correct, because if it was, it would have been in the statement. And that kind of approach really, as I say, should underpin your general preparation to any cross-examination. So just to conclude, and I'm very conscious we're 2 minutes to 3, we can't run over. We've looked at a very quick insight, a little overview really of cross-examination. I hope it's a little bit clearer as to just what it is, questions of the other side, the kind of questions, lead, put points really assertively, try and restrict the witness to short answers, don't learn anything new, don't get into an argument, think of it as an opportunity to demonstrate points which help your case, don't try to persuade the witness, try to persuade the jury through logic, really, that these facts make sense. And when you're dealing specifically with inconsistencies that the witness has given, similar approach, try to demonstrate why today's account is unlikely to be correct, if it's an exaggeration or if it's including something which would have been in their original statement. I'm conscious that's a real whistle-stop tour through just a few things, and it's not possible to go into any more depth. But thank you, Clara. Thank you, Monish, for saying, and Melissa. I hope that has been useful. If you've any queries following from that we haven't been able to get to in the chat, I know, Millie, thank you very much. You've dealt with some questions there. Then do get in touch or connect on LinkedIn, and look out for other sessions that we run at BPP as well, face-to-face sessions in centres as well as online sessions. So do connect with us there. Nahal, I think my clock's just changed to 3 o'clock, right on the dot.
Perfect. Thank you.
Timekeeping is improving, if nothing else.
Thank you so much, Millie and Nigel, for this really super insightful webinar, cross-examination. I really, really enjoyed listening in. Thank you also to everybody who joined us as students and asking all those questions and being super engaged. Today, if you have any questions at all, please feel free to email, add on LinkedIn, and also check out our Target Jobs website for future webinars as well. So thank you all and have a wonderful day ahead.
Thanks, everybody. Bye.
Bye.